I want to thank you for tuning into our program today. Today we are looking back on the 25th anniversary of the New York Court of Appeals decision in matter of Jacob back in 1995. It is the case that established second parent adoptions for gay couples actually and straight couples. And we've brought together a wonderful collection here of people that were in the room where it happened, to quote the Hamilton musical. And I'm delighted that they're all here to join me today. To my left here in the square in Zoom is Dean Alicia Ouellette, who is the Dean of Albany Law School. In the two bottom squares, we've got Judge Carmen Beauchamp Ciparick, who was a Court of Appeals judge from 1994 to 2012, and is today returned to the practice of law at Greenberg-Traurig. And the other square is Judge Howard Levine, who was a Court of Appeals judge from 1993 to 2002. And he also has returned to the private practice of law at Whiteman, Osterman, and Hanna. I thought I'd start today by just asking all of you to give us a sense of who you were personally and professionally in 1995. And maybe we'll start with Dean Ouellette. Who were you in 1995?
So in 1995, I was a fairly recent graduate of Albany Law School, and I was a clerk to Judge Howard Levine, which was the best and most important professional experience that I ever had. So I was what they call an elbow clerk, working at his side along with another clerk. I was also a mother to two young kids. You asked about personally, so there you go.
And Judge Ciparick, I sort of spoiled who you were in 1995 in my intro, but maybe give us a greater sense of where you were in your life and what sort of had led up to your Court of Appeals appointment.
Well, how are you? You have to tell us where you were in 1995 also, at the end of this round. Well, I had recently come onto the Court of Appeals, in January of 1994. So I was there a year, and I also had law clerks who are not with me today, unfortunately, but both of them, one still works in the court system, and another one is at Fordham Law School. But in any event, I had been a Supreme Court justice for 11 years. Before that, I had been a criminal court judge in the New York City criminal courts. And I spent 19 years on the Court of Appeals. So altogether, 34 years on the bench, about 15 years on the trial court and 19 years as an appellate judge. At the time I went on the court, I had a college-age daughter. I have to say she was a tremendous cheerleader, and she helped shape my opinions on matters. And my husband was alive at the time. I was doing the commute back and forth from New York City to Albany. And life was good. Life was great at the Court of Appeals with my wonderful colleagues, Judge Levine and our Chief Judge at the time, Judge Kaye. So that's where I was in 1995.
And how about you, Judge Levine?
Well, I was on the court, and I had the pleasure of having 2 years spent with the later Dean of Albany Law School. And we had a wonderful relationship, which I think was mutually satisfying and very productive in terms of the work of the court. From my background, I had a lot of years of public service starting around 1960. I was a prosecutor for 10 years starting in 1960. And most relevant for our discussion today, I was a family court judge for a full decade in Schenectady County from 1971 through 1980. And then I was elected to the Supreme Court and promoted to the appellate division in 1982, where I spent a very pleasant period of time. and until my appointment to the Court of Appeals.
Wonderful. One thing I wanted to sort of give our viewers a sense of before we maybe start talking about the specific case is where, where LGBT rights was in 1995. There's really been a sea change in the last 25 years in terms of the legal landscape for LGBT people and their families. The US Supreme Court has really stepped into the fray, especially in the last 10 years, and sort of established these sort of 50-state solutions that apply to the whole country to deal with some of these issues. But I want to bring people back to 1995, and what is interesting is really the New York Court of Appeals was really the sort of primary source of action on a lot of these issues. It was an interesting state law situation in New York for many of these years because there was many statutes, family law statutes, what we call the domestic relations law in the New York Code that hadn't been updated in decades, but had provisions that could arguably apply to gay families. And in a series of cases that came to the Court of Appeals, really the sort of lack of legislative action left the entire question in the lap of the Court of Appeals to determine whether or not these statutes might apply to LGBT families. And just to give people an example, one of the main cases cited in Matter of Jacob is a case called Adoption of Robert Paul P. And it was actually a gay couple trying to adopt each other. I mean, that's really the lack of relationship recognition was such that one couple even tried to adopt each other. So it's very. Can any of you maybe give a sense of what your experiences were with LGBT issues in the years leading up to Matter of Jacob? I know we were just chatting about it, Judge Ciparick. You had seen a little of this in some of your cases.
I had seen a little bit of it in as a trial judge. At the time, that are now called Article 81 proceedings, they were called conservatorship proceedings. And there was a young man who was afflicted with AIDS, and his partner, obviously, somebody needed to be appointed guardian because he was losing his cognitive functions were deteriorating, as well as his other physical functions. And there was a battle between the young man's parents and his partner as to who should be the conservator, the guardian of his property and his person. And it was really, it was almost like a matrimonial proceeding. There was a lot of acrimony between the parents and the partner, a lot of blame, a lot of name calling. If it wasn't for you, my son wouldn't have been gay, my son wouldn't be sick today, etc. So there's a lot of that. But we finally reached a resolution. We finally resolved it. We resolved it basically by allowing the partner to be the young man's guardian of his person, and allowing his parents to be the guardian of his property. They were concerned about his property. He was a relatively successful entrepreneur, and they were concerned about that. He had siblings. They wanted to protect their rights. But we reached a settlement. But after a lot of name calling and a lot of acrimony. But so that was really my first legal encounter with some of these issues. And then, of course, when I went to the Court of Appeals, a year into my being there, along came this case, and I knew where I was on the issues, and Judge Kaye so deftly put together this wonderful decision where she meshed together all the statutes, not only domestic relations law, but the social services law, etc., and found some ambiguity, looking at all these laws together, saw that the direction of the legislature had been to not to discriminate against children of unwed parents, not to discriminate against children against parents because of their sexual orientation, etc. And she found that the best interest of the children would be served by allowing the second person marriage. And I totally agreed with that. I was on board from the very, very beginning, as was Judge George Bundy Smith. Judge Levine, however, was not as convinced. He was more of a textualist at the time, and he was looking at the statutes. Maybe we should let Judge Levine discuss his journey toward reaching joining the majority opinion.
Let me just read quickly. There's one passage, and sadly we can't, the person I most especially wish could also be part of this panel has passed away, and that is, of course, as you mentioned, Chief Judge Kaye, who wrote the majority opinion, but she did write about it in the book that came out last year. She wrote a lot about it in this book, and there's a very interesting passage here that you just sort of previewed. And she said it was argued June 5th and not decided until November 5th. For the Court of Appeals, a 5-month delay between argument and release of a decision to this day is most unusual, signaling not only disagreement evidenced by the dissent, but also that someone in the 4-3 mix, thankfully in retrospect, was keeping the door ajar, unwilling to finalize the vote. So Judge Levine, will you take it away from there? Because she was talking about you, we now know.
That was me. That was me. Let me just say a few words about Judith Kaye in terms of her leadership and her interest in family matters. Even when she was an associate judge on the court before she became chief judge, she had expressed a fundamental commitment and interest in family matters and children's matters. She was invited, again, just about the first 6 months of her succeeding to the chief judge position, she was invited to be the principal speaker at the annual banquet of the American Law Institute. Now, the ALI is a prestigious body that consists of practitioners and law professors and judges. And she chose a topic that was unusual for the ALI, and that was that lawyers and judges should be committed, and law professors should be committed to matters involving the family, and especially matters that impinge upon the best interests of children. And surprisingly, that was not received well by the female members of the American Law Institute. They were critical of the idea, well, family law stuff is not what we're dealing with. Our important matters is molding the law and commercial matters and torts and so forth. So she thought that Judge Kaye had blown this opportunity to speak to this august body. When that came out, and I was there for the speech, and I was also there, and the New York Law Journal had reported the dissatisfaction of the female members of the Institute. So we had, this was really the beginning of a friendship between us. I wrote her a note saying that I thought she did beautifully, and it was a wonderful subject, and it was an appropriate subject, and I was very proud of it. And that was really the beginning of our friendship. That was several years before I was to join her on the Court of Appeals. In terms of this particular case, I don't see myself necessarily as a textualist. I view myself as looking for, in terms of statutory interpretation, looking for what the purpose of the law may have been. And Alicia can verify that. I think that was the first place I looked. What was the purpose of this particular statute? And that would affect how it was to be interpreted. But this was a tough row to hoe textually. You can't ignore text, of course. And the problem with it is you had section 110 of the domestic relations law, which did permit any adult single unmarried person to adopt. So in both of the cases, the Jacob case, and I can't remember the name of the other
Dana.
child in the other case.
Dana.
What was it?
Dana, matter of Dana.
Dana, that's right.
Yep.
One child was the mother of that child had a intimate relationship with a male. That was a heterosexual situation, but for one reason or another, I can't remember why, they were not legally able to marry. The other case, of course, was a lesbian couple. And again, the partner of the mother was an adult, and therefore, as an unmarried adult, also had the right to adopt. Now, the problem in the case is you had another section, section 117, which basically said that upon the judge issuing an order of adoption, the natural parent shall no longer have any rights or responsibilities for the adoptive child. So you had a catch-22 situation in which the whole purpose of an objective of the parties will be defeated, because once the adoption by the partner of the natural mother, upon that person becoming a parent, the natural mother would lose her rights to the child and responsibilities with respect to the child. So that was basically the conflict that you have between these two sections. And it was perfectly understandable why the dissenters reached the conclusion they did, and I was leaning with them when this case was first conferenced, right after argument, because it seemed very simple. You would want to make these two sections consistent. That's a principle of interpretation, and if they were consistent, then the granting of the adopt, it would not apply in the situation that we had, where the natural mother wanted to retain rights to the child, but extend those rights as well to her partner. And that's where I was. And,
can you maybe just say a word about?
It bothered me no end.
Can just say a word, maybe you and Judge Ciparick, about what is the conference process like after a case is argued and submitted to the court? What is the sort of the next step where you guys start to hash out how it will be resolved? Can you take us inside a conference and what it feels like, what it was like to be in that room talking through the case?
Well, the seven of us sit around a conference table in seniority order. The chief judge and then each of the senior judges. At the time of this case, I was a junior judge. Judge Levine was my closest sibling. He was 4 months my senior. So there was a random draw for the case. I don't recall exactly who drew it. It may have been Judge Kaye, may have been Judge Bellicosa. I'm not sure who spoke first, but the reporting judge would have the obligation of speaking first and reporting the case and the rationale for how they would rule and the rationale. And then going around the table in order of seniority with the junior person speaking first, would go around the table until we reached some sort of consensus. And the hope was to get 4 votes. That particular conference, obviously, there were 4 votes going the other way, and 3 votes going the way that myself and Judge Smith and Judge Kaye had voted. So what happens in the conference is, we go around one time and then we keep going around. And I know Judge Kaye always tried to achieve consensus where she could. And sometimes she would put a case over. Well, let's talk about it tomorrow. We can't reach consensus today. Let's talk about this tomorrow. Or let's put this aside. We'll talk about it next week. We used to have 2-week sessions at the time. So it's a give and take. It's a give and take. And what happened in this particular case, when we adjourned, this was heard in June. When we adjourned for the summer, it was fourthly going the other way. And the good graces of her law clerk, Robbie Kaplan, at the time, and Judge Levine's law clerk, Alicia, there was a decision, to put it over. Well, let's see, I'm not quite there yet. I could be there, I'm not quite there yet. So let's put it over until September when we meet Zoom, or August, the end of August, and we came back for election cases and see where we are there, and see who gets the majority writing and who gets to write for dissent. So that's what happened there. But other cases we were able to resolve, and usually the practice of the court was if you heard a case in June, you'd have a decision by July. If you heard it in October, you'd have a decision in November. That was the practice of the court, and very seldom the cases go over. Sometimes it'd go over one session, but to go over, well, this went over the summer, plus obviously when it came down to November, it went over even a bit more after that. And that was very rare. We had that with some of the capital punishment cases. Those were also close, they were forthright. But it was very, very rare for a case to go over. But obviously there was a lot of thought going on, and a lot of hand-wringing going on, a lot of lobbying between the chambers going on, and finally we reached what I believe, we all believe, was the correct result, and we're very happy that Judge Levine joined the majority.
And Dean Ouellette, can we bring you into the conversation now a little bit? Can you talk about the role of law clerks in a sort of multi-member appellate court like the Court of Appeals, and sort of what were you doing in that sort of June to November period? What sort of, and I think it'll be interesting for law students who might be thinking about clerking. Can you take people into the role of a law clerk, and what sort of fills your day in a situation like this?
Sure. So each chamber is different, and each judge tends to use their clerks in different ways. So I can talk about my relationship with Judge Levine and what I saw from the other chambers. Judge Levine would have his clerks prepare cases ahead of time. We'd do our best to sort of brief them and get them ready, particularly ones that we knew that were going to be very difficult. So we got sort of the first shot at writing up a memo for the judge on kind of summarizing the arguments that both parties had presented, and doing our own, we were very young lawyers, but giving our best take on the case and where the things we thought the judge should think about. And we also had the opportunity to talk with the judge right after arguments. We would always watch argument. I would know as a law clerk if the judge agreed with what I was thinking about. If he asked a question that I was like, oh, you got it, but I didn't always know where he was before argument. Sometimes we talked about particular cases. He would call me in and say, you missed this, and we'd have to sort of dig a little deeper on something or take a look. But immediately after the argument, we would go back into chambers, and that was really one of my favorite parts of clerking, because the judge would talk you through. So you had all the cases as a clerk. We were assigned days, so we had written up summaries. We knew the cases that were being argued that day, and we watched the arguments, and then we kind of the judge would have a snack and tell us where he was leaning and what he thought was going on, and we would decide the work that would need to go on that night. And before the judges went into conference. And then the next part of clerking that was really fun was when the judges went into conference, the law clerks did their own little meeting. And there was at the Court of Appeals, at least while I was there, the law clerk network was really first of all, we were really close with one another, even though we all had home chambers. But when we came to Albany for argument weeks, we saw each other every day, and we really lobbied each other to lobby our judges, and would sometimes Judge Levine would actually send me on little missions, like, go see how Judge Tatone is feeling, and I'd go talk to Libby, and we kind of try out an argument. And that was very, very true with Matter of Jacob, that the Law Clerk Network, we were calling each other, it was pre-email and whatnot, so we were calling each other before the case was argued. What do you think is going to happen? We knew this was an important case, and felt very strongly about how we thought it should be resolved or not. I had the good fortune to work for a judge who allowed me to make whatever argument I wanted to make and listen to me, and he can talk about his decision making, because really the fact that he held the case over for the summer was it was a big deal, as I recall it, Judge. And you know what happened after that was, you know, the judge said, we really, you know, this is a hard case, and there has to be an intellectually honest answer here. And one of the things that we talked about a lot in chambers was there's this ambiguity, and there was this constitutional doubt brought if you read this statute literally and took away the ability of these children to have their parents adopt them who wanted them, there would be constitutional doubt. And we talked about that, and the judge said, find me some precedent. And I did my best to find something, and eventually he got where he's going, where he went.
And this morning, I actually, before we started recording this, it's the first day of a Supreme Court confirmation hearing. The word textualism is being thrown around a lot in this hearing. Maybe Judge Levine, can you maybe just talk a little bit about the schools of thought when it comes to statutory interpretation? What does textualism mean? What are other schools of thought? And how does a judge approach a statutory interpretation case?
Well, there are differing philosophies among judges, including Court of Appeals judges and Supreme Court judges as well. The classic view of a textualist is, and this is now, we're talking about a Scalia type judge, and perhaps an Amy judge as well, Amy being the newest nominee for the court, the Supreme Court. In any event, you look to the plain language of the statutory provision at issue, and you interpret that plain language in the meaning of that language at the time of the enactment of the statute. That's what a textualist does. The problem for me with that is that language, particularly the English language, and really part of the richness of the English language is that there is no precision in terms of the meaning. In most cases, you can come close, but in terms of real absolute binding meaning of a statute, I haven't met a statute yet that I couldn't find several different meanings of, and this was, of course, one of them, which gives rise to the way that we resolved the case. We basically looked at the fact that there were these two opposing provisions, which in itself would create an ambiguity. And then the question is, how do you interpret it in light of that? How do you resolve it in the light of that ambiguity? And this is where canons of construction of statutes came into play. And you can choose any number of them that could apply, but one that I found a principled, honest way to get to the result that I was hoping we couldn't, the one that Alicia was heavily involved in a conspiracy with Robbie Kaplan to convince me to go the other way. This was a conspiracy theory, if I might add. In any event, I found it my own personal intellectually honest way was to use the canon that enjoined the interpreting judges to pick an interpretation that or avoid an interpretation that would have serious constitutional validity questions in it. And that, of course, was not hard here, because we were saying basically the then majority was basically saying that these children could never have two parents, two legal parents to take responsibility and provide love and care in a secure situation where the children knew that that parent would be with them for the parent's entire lifetime. And that's what we were driving at, and found it compelling. And to carve out as an exception to that kind of permanency for a case where the partners, the mother and her partner, were not married for reasons that they couldn't overcome, was consigning them essentially to a limbo that was only based arbitrarily on the marital status of the mother and her partner. So that's the way I found comfort in joining Judge Ciparick, Chief Judge Kaye, and Judge Bundy Smith to go with what was best for the children in both these cases.
And just to further explain sort of the stakes, 4 years earlier, the court had heard a case known as the Allison D case, and that involved interpreting the word parent in the statute that says who has standing to bring a custody or visitation petition after a relationship breaks up. And I know, Judge Ciparick, you later heard a case that brought that issue back to the court in 2010, the Deborah H. case. But this was really the reason the stakes were so high here, because if these couples were to break up, the second parent was really left in a lurch where they had no ability to, if the other parent didn't want them to stay involved with the raising of the child, they had no legal standing to come into court and seek, some level of custody or visitation. Can you talk about that a little bit, Judge Ciparick?
Well, I guess the good news is that Allison B has been overruled.
Yes.
And also further good news is that Section 110 of the Domestic Relations Law has been amended.
Correct.
To allow for these different parenting formulas. Well, we started out by talking about the evolution of the law. I sat at the Court of Appeals for 19 years and saw that evolution, and was very pleased. And Judge Kaye and I also dissented on the marriage equality litigation that was brought in our court. And then I think it was 7 years later, we saw the legislature take that up, and the governor sign marriage equality as law in New York. So I like to think that we were at the forefront of the conversation that allowed for these legislative changes, and also got people thinking about these issues and realizing that society was changing, and we had to go along with it. I just saw that in so many different areas at the court. I mean, Judge Levine and I were involved with education funding. We saw the way that evolved through the courts. I mentioned capital punishment earlier. We saw that evolution, and no appetite by the legislature to bring that back.
You also wrote the opinion in the Yeshiva University case.
Yes, that involved a student and her husband. That was, I think, were they married? I'm not sure if they were married or not, but it involved housing
Exactly.
for the students, and whether or not they had to be, whether or not two single people, or whether the same sex or opposite sex could cohabit in marriage housing, could live in marriage housing. And of
Correct.
course, the university was opposed to it. I mean, they were a religious, university, and they were opposed to it initially, but we said it was an accommodation, it was a public accommodation, and we said they couldn't discriminate. Those issues came up with contraception and health benefits, and whether religious institutions could prevent their employees from receiving contraception as a health benefit. So we're seeing all this evolution, and it's been wonderful for me to be a part of it.
Yeah.
And Judge Levine mentioned the Senate hearings that are going on right now as we speak. I was watching a little bit of it this morning, and it's just so interesting to have been part of that and part of the making of the sausage over the years. And I'm very proud of the work that we did, and as Judge Levine is as well, and I'm just happy to see the evolution of all these issues. Can I go back to something that I'd like to, there's a quote that I'd like to read into the record, and Dean Ouellette was talking about she and Robbie and the conspiracy and the lobbying of law clerks. I asked my law clerk if he had what recollections he had of this, and this is what he wrote. He wrote me an email, said several things. He said, "I do remember being held captive in the stairwell of 20 Eagle Street by Robbie Kaplan, as she lobbied me very intensely. I remember trying to repress my laughter and saying something like, 'You don't need to press so hard. I'm pretty sure my judge is 110% with the chief on this case.' And still she continued on. She wasn't leaving anything to chance." So Robbie's not with us today, but I know you'll be interviewing her a separate time. But certainly she was a tremendous advocate, and she and Alicia helped shape this writing. And you asked what the role of the law clerk is. In many cases, the law clerk is the one who shapes the writing. In my chambers, I would have my clerks write an initial draft, and then I would work it over and make it my own. But there was so much good work that was produced by the law clerks, and oftentimes there was very little editing that would have to be done. So I'm not quite sure how this came together, but I know that Dean Ouellette and Robbie Kaplan had a lot of input into that wonderful writing that was Matter of Jacob, which I so happily signed on to.
And just to bring Judge Kaye back into the conversation, another passage in her book, she talks about Matter of Jacob being her greatest source of satisfaction. And it's amazing when you think about the kind of legacy and accomplishments she had, that she would say that about this one case. Another very interesting matter that comes up in her book, and that's been brought back into my thinking, I guess, in the last few weeks with the tragic death of Justice Ruth Bader Ginsburg, is back in 1993. Judge Kaye was at least initially perhaps in the mix for that vacancy on the U.S. Supreme Court. And she writes about in her book how she eventually told the Clinton administration to take her name sort of out of the hat, so to speak, because she wanted to stay in Albany and stay on as Chief Judge at the New York Court of Appeals. It's sort of incredible to think about someone potentially turning down, who knows what might have happened, but potentially turning down a spot on the U.S. Supreme Court. Can you maybe Judge Levine and Judge Ciparick talk about why the New York Court of Appeals was so special and so important to her?
Well, I think part of the appeal of staying as Chief Judge was not merely the work and output, the work product of the court and decision making, but the Chief Judge of the Court of Appeals is also the Chief Judge of the state of New York. And that is essentially the CEO of the entire judicial system. And I think that she was an activist as a reformer in all aspects of the legal administration of justice. and she would be giving that up to be an associate justice on the Supreme Court. And I think that was a big part of the reason why she took herself out of the mix with that. I think she would have been, could very well have been the pick by President Clinton. She had a great experience. She was a good writer. She had a great reputation, a national reputation already. And her as a generalist, she would have been very appealing for the court. But I think Judith really saw being Chief Judge of the state of New York as a great opportunity to do good of the people of the state, and actually also as an example to other states in terms of their administration of justice. And I think she achieved those goals. She did great reform within the constraints of the state constitution in terms of court reform issues. She was a great supporter of family court, giving family court the resources it needs, which was something new. The problem, I think, before her time was, and this goes back to what the court rulings in these kinds of cases, which were basically pro-straight and anti-gay, I guess you would have to say. I think that the judges were very good judges who were in that category, but they had no experience with the kinds of varied situations involving families and different kinds of families. They needed a little family court experience. That's what they needed. And that's the nice part about a collegial court, where all the members bring their own personal experiences into that conference room. But Judith, basically, without experience in family court, and in her whole background had nothing to do with family law matters. She was a corporate litigator before she went on the bench, but nonetheless, she had very strong, passionate interest in families and children, and the state was better for it.
Absolutely, I agree. She created problem-solving courts to deal with various issues like drug courts and courts involving veterans and courts involving mental health and domestic violence courts. She ran the gamut. She saw the problems in society and she tried to resolve them. How can the courts help? How can they help? So she's community courts is very, very involved in diversion and trying to divert cases out of the criminal justice system. She would cry at graduations. When she'd go to her drug court graduations, she would cry because the families would be there and the young people who had been involved in these diversion programs, they were now drug free, and she would take such great pride in that. So she was very loving, very caring toward everyone. I mean, she was also very interested, and Judge Levine mentioned her being a commercial litigator. I mean, she helped establish the commercial division in the courts. And it's a top-notch court to this day. It's a top-notch court, and it deals with very heavy cases involving lots of money. So she didn't abandon any part of the docket. She was there and trying to make it better, and she did make it better. It was a pleasure to work with her all those years. And Judge Levine made you the same way. Her legacy's live on. Her legacy's live on. I mean, Judge Lippman and now Judge Fiore, they haven't dismantled those courts. Those courts are still going strong. They were courts that were established under her, under her leadership.
Absolutely. This has been a wonderful trip down memory lane. I really can't thank you all enough for doing this this morning.
Thank you, Matt.
All right.
And we enjoyed it.
All right. I have Robbie Kaplan joining me at the right now, and I want to thank her for jumping on to share a couple of her memories of the matter of Jacob case. Robbie, can we start with just who were you personally and professionally back in 1995?
That's a very profound question. But let me try to answer it with respect to the matter of Jacob. So
Yeah.
I was a law clerk at that point in time to Chief Judge Kaye. I had come to that clerkship from working as an litigation associate at Paul Weiss. And I fully intended, as I did, to go back to Paul Weiss after the clerkship. But most importantly, I think from kind of the perspective of the case, while I was out to certain people, I was not out to everyone, and I certainly was not out to the Chief Judge Kaye at the time.
And what was the state of, can you give people a sense of what the state of LGBT rights was in 1995, both in New York and nationally?
Yeah, pretty dismal.
Yeah.
New York at that time was one of the rosier jurisdictions, I hate to even use that word, in the sense that there was a famous case called the Braschi case from
Yep.
the 80s that Judge Tatone had decided about a couple who had a rent control apartment and one of the men died of AIDS. And unlike a lot of other jurisdictions, New York, the Court of Appeals, in a decision by Judge Tatone, had said that the surviving partner, no one was married at that point, the surviving partner had the ability to keep the apartment. There were some protections, I think, in New York City.
Right.
For gay people. I'm not sure there were any statewide protections. I don't think there were at that point.
No, that was later. Yeah.
Yeah. So it, while overall everywhere it was dismal, New York was a little bit better than other jurisdictions. And honestly, it's hard for people today to kind of wrap their heads around this, but there, if anything, I'm kind of or try to be a kind of a rational lawyer. So I don't think that it's an exaggeration to say that there was likely a connection between my being very careful about, who I told about my sexual orientation and the fact that there were just such limited protections for LGBT people everywhere, as well as in New York.
And really this is the era before the US Supreme Court had really gotten involved in gay rights. So another sort of interesting thing is this is really the era when state high courts were really the primary actors in this area. Is that right?
Right. Romer was 1996, so I guess
Yeah.
Romer's after this.
Yeah.
That's exactly right. So all the Supreme Court decisions up to this point were overwhelmingly negative.
Yes.
And the lower court decisions following that, feeling bound by precedent, were the same. And you were in an era a little bit led by Judge Kaye and the late Justice Brett, both of them now having died, to kind of revive state constitutionalism in an era in which it was widely perceived that the Supreme Court had kind of become very conservative on a lot of civil liberties issues. Now, again, it's kind of ironic saying that today, comparing to the Supreme Court today, particularly if Amy Coney Barrett gets confirmed, but that was what it was like at the time.
And one of the other, New York specific things was nothing was ever sort of affirmatively banned in New York, but nothing was ever affirmatively granted either. So the ball always ended up in the Court of Appeals lap, so to speak, in terms of there was this weird legal limbo in New York where the legislature would never really act on something affirmatively, but they also had never banned anything either.
Right. It's exactly right. It was kind of this don't ask, to use an expression that has resonance in this area. It was kind of a don't ask, don't tell era.
Yeah.
And while I think New York, again, was somewhat more open, probably a lot more open than a lot of other states, even with respect to the New York City legislation that had finally gotten through, that was a very long, hard fought battle.
Right.
to even get that through. And I know because my wife, who's far, far braver than I am, was at the forefront of some of those efforts.
Yeah. Do you remember, sort of just as a law clerk, how this case came on your radar? How did you come to know about this case arriving at the court?
And so the Judge Kaye had 3 clerks.
Yep.
We had 2 at the end because someone left early, but I can't, this might have been toward the end, so maybe there were only 2 of us. The cases got divided, I think randomly, as I recall. I don't recall there being any kind of review or anything like that about which clerk got which case, although I tended to get more of the civil stuff
Mm-hmm.
because that was really what I liked doing. And I can't remember other than it ended up on my docket.
Yeah.
And you know, I don't even recall whether there was a process for that to happen, but it ended up on my docket.
And you talk about in your book, originally it was sort of 2 separate cases, and they sort of consolidated this case involving a straight couple and a case involving a gay couple.
Correct, which I wasn't, at the time I wasn't happy about.
Yeah.
Go
Go ahead. Sorry.
No, and the reason I wasn't happy about it is because there was no question under New York statute that for the straight couple, if they got married, then the father or the mother, depending on which it was, had the ability to adopt as a step parent, which was specifically provided for in New York statutes.
Right.
And it seemed to me that claim, and this is funny because it's presaging what came later, but that argument that, you know, it's too inconvenient for me to get married, or I have some ideological objection to marriage, whatever you think of that argument, it seemed to me that it paled in comparison to the lesbian couple who had no such option. Right.
So there were basically 2 questions, I guess, in the case in terms of statutory interpretation. One was whether the single unmarried person just had standing under the statute to adopt. And then there was the issue of the termination requirement. That
Right.
Basically in adoptions, generally you're terminating the parental rights of the existing parents in favor of the adoptive parent. And can you just give a sense of how did the court ultimately decide to resolve those 2 questions?
Yeah, so as I remember, and I'm an old lady now, but as I remember, the far bigger problem was the termination issue. Because when I just referenced the step parent provision, and that did allow a step parent to adopt, typically a stepfather to adopt, without terminating the rights of the biological father. And that's something that obviously came up a lot with second marriages.
Yep.
The new husband would adopt, and it didn't interfere with the biological father's rights. In this case, that would have been a disaster, obviously, because the child for the 2 lesbian couples was the biological child of one of them. And the last thing in the world that anyone wanted, which let me back up, in all other cases you would have to terminate.
Yeah.
And so the idea that you would have to somehow terminate the rights of the biological mother in order for the non-biological mother to become a parent certainly didn't make any sense, and was really obviously not an option that anyone would ever pursue.
And one other thing would add to this conversation is the Allison D. holding from a few years earlier. If a gay couple broke up and they were raising children together, the non-biological parent would have no, under the Allison D. rule, have no standing to seek custody or visitation if the other parent wanted to be that way.
And I guess why that's why I'm more focused on termination, because Judge Kaye had dissented in Allison D.
Yep.
And so she was kind of locked in on standing, and so that wasn't the hurdle for us.
Yep.
The real hurdle was this kind of termination provision and how it would apply in this context, given the fact that there was a statutory exception for step parents.
There's been so much talk since this summer in sort of LGBT legal circles about textualism after we won, the Bostock ruling on a textualist grounds. But Judge Kaye's opinion in this case was really the exact opposite. It's not at all about just focusing only on the words in the statute. In fact, we would have lost this case if we just looked at the pure words in the statute. Can you sort of explain sort of how Judge Kaye thought about statutory interpretation in this case?
Yeah, look, I think the one thing that is kind of underlying the whole case, and that you certainly see at the end of the opinion and some language that, as I recall, was written by Judge Levine, was this looming constitutional question.
Yep.
So you had an issue where the statute on its face literally only applied to step parents who are married to the biological parents. On the other hand, particularly in a case with, as was the case in Dana, where you had two moms and one of them was the biological mother, that statutory language was creating really perverse results, and results that obviously were so not in the best interest of the kids involved. And as I recall, the constitutional issue was not preserved in the case. So whoever had litigated the case at the trial court had not raised a claim that the statute, at least as applied in that circumstance, was unconstitutional.
Yeah.
And I think everyone, certainly everyone on our side of the case, was convinced that it was unconstitutional, that it would be improper to deny. And it's interesting, back then, because it was politically and socially more palatable, the way to look at it was the interest of the child. Right? No one was talking, even in matter of Jacob, about the interests of the lesbian parents. The crucial issue was the interest of the child. And Judge Kaye, to her great credit, had spent many years kind of focusing on child welfare and how the law could be more promoting the interests of children. So that was the context. And I think everyone agreed in that context that, at least from the perspective of the child, it would have been unconstitutional to say a child who had two moms only had the right to one legal parent, whereas a child who had a heterosexual couple as parents had the right to both. But again, there was a real problem, a real dilemma, because that issue had never been raised. So we ultimately came up on the compromise that, which I think was absolutely correct, which is that you need to read statutes and interpret statutes to avoid constitutional issues. But I definitely agree with you that I don't think Justice Gorish would probably adopt that approach in a similar case.
Can you give a sense of what the role of you as a law clerk was while the case was being sort of internally resolved? It's a very, you can speak generally too, but just sort of what is the role of a law clerk on a multi-member appellate court? Sort of what was going on behind the scenes the summer this case was being decided?
Yeah, so I wouldn't be saying any of this other than the fact that before she died and before I published my book, I spoke to Judge Kaye about this, and she gave me permission to talk about it. So without that permission, I wouldn't be doing this. But generally speaking, there were a bunch of things going on in the background. So Judge Kaye and I had become very close, and we're both kind of we're obsessive nerds, and we both kind of focused very hard and worked very hard on the cases, at least the cases that I was handling, and she worked hard on all the cases. And at that period, there had been a number of cases where we had succeeded already, up to even before Jacob, in what's called turning the court, which means after argument, the first time that the judges would conference the case and discuss which way each one was voting, Judge Kaye was originally in the minority, and then we managed to persuade another judge to join us, and then became converted to a majority opinion. So that I don't know the exact number, but it had already happened, I'd say 2 or 3 times before matter of Jacob, and that was a big deal. That did not happen very often, and does not happen very often in the Court of Appeals. So there was already that backdrop. The other thing that was going on was there was kind of a huge public relations onslaught against the court and judges, centered in the New York Post, but at this point kind of everywhere in all the tabloids. And as I recall, the kind of the spark that set it off is that there was a judge in Manhattan who released someone, I think, on bail, and that man, I think it was a guy, then attacked or raped another woman. Obviously, terrible set of facts. And people don't, not everyone listening to this may know this, but Judge Kaye really had two jobs, each of which were more than a full-time job. Which, what I mean by that is the Chief Judge of the Court of Appeals is not only the Chief Judge of the court, but is the Chief Judge of the court system, the New York State court system, which is the largest court system, at least at that time, probably still in the world. And so Judge Kaye, understandably so, was kind of beset at that point with these, you know, almost hourly attacks being made on judges and the power of judges because of this situation with the criminal judge in Manhattan. So it was, I would say, it's fair to say it was a fraught time.
Right.
And when the case was argued, as I recall, in the late spring, beginning of June, so even later than that, beginning of the summer, the court always takes the month of July and part of August off, and then it begins again with what are called election cases about the election laws in early summer. And Judge Kaye and I never had any dispute whatsoever in the case about the merits and about which way she should go or the court should go. But we did have, I think, what was really our only argument that I can recall, certainly our only strategic argument ever, when I clerked for her about the case. And that is that I wanted to hold over the case over the summer. And she was under a lot of pressure, I believe, from Judge Bellicosa and others who were the majority, not to do so. And one of the things I used in that argument to her is that I, you know, she kept saying to me, well, we're not gonna be able to turn the court here. And I said, well, it's not about turning the court. You know, you could be writing a better dissent. And I don't have enough time, you know, I haven't had as much time as I would have liked to work on it because we were, you know, I worked with Judge Kaye also on some of her administration of the court system. And I said, I've been spending so much time on this judge's attack that I haven't given it the time it deserves. And ultimately I persuaded her to hold it over, which was a brave act for her too, because I don't, you know, my sense is that the judges who were then in the majority were not happy about that. And again, someone should look at this, excuse me, someone should look at the statistic, but I think it still is an exceedingly rare thing for the court to hold something over. I know this term, oh no, they didn't hold Sumner's their votes over. They just haven't scheduled the argument.
Yeah. No,
Yeah.
even in her book, she talked about what an extraordinary thing it was to hold the case over the summer in her book.
Yep.
Can you give people a sense of why you think this case?
And the funny thing about it is I knew if I argued to her, we could get another vote, which is of course what I secretly hoped.
Yeah.
That I wouldn't win the argument. So
I will say too, and Judge Ciparick, when we recorded with her last week, she emailed her law clerk, and her law clerk said he vividly remembers you lobbying him for Judge Ciparick's vote. So it's still vivid for these other law clerks 25 years later.
Well, one of the things that I had done, which is great about this, I learned so much on this job, but one of the things that was great about it is, so let me kind of tell a little story. So when I first got to work for Judge Kaye, we had our first session in Albany. The judges had a tradition when they would go out to dinner every night that the court was in session. And Judge Kaye's clerks at least had the tradition where they would basically order like an extra sandwich at lunch and sit at their desks and wait till the judge got back from dinner, because she would often stay in the office until midnight.
Wow.
And that was kind of the day. And I remember saying to her, like, look, this is just too much. Like, no one can sit at their desk, and I'm known as a hard worker, but no one could just sit at the desk and have, 16 hours a day. I said, I think, what if I organize the clerks going out to dinner, rather than just the judges? And at first, I think she was a little nervous about it. She said, well, can't you just order in? And I said, Judge, it's Albany. Like, where do you think, it's not the Upper West Side. We can't just order in so easily. And so we started this thing. I have no idea if it continued, but we started this thing where the clerks would go out to dinner kind of at the same time. And a completely unintended consequence of that was that it really gave the clerks a lot of ability that I certainly used to kind of talk to each other, find out where the other judges, where their heads were on cases.
Yep.
and have this real opportunity to kind of persuade, or to try to persuade judges to, or other clerks to persuade the judges to come to their side. And so by this point, by the time we were at matter of Jacob Dana, this had been going on for some time, and she loved, she quickly appreciated how helpful it was. So she was, at that point, a big supporter of this. And so I'm sure I did that, multiple times at these dinners. I have no doubt of that.
And the stairwell is also apparently a place where you would, several people have mentioned the stairwell and you lobbying in the stairwell.
Wow, that's embarrassing. I don't remember it, but I certainly don't deny it.
Let's pull the conversation forward a little bit forward from 1995. And you've also wrote about this in your book. Why do you think this case was so important for what would come later for LGBT families and relationship recognition?
So we had a problem. Well, let me say one thing before I answer the question. Like at the time, while I was a lesbian and I had a girlfriend, I don't think it really ever occurred to me that I would be in the situation of needing to do the adoption of matter of Jacob and Dana, honestly. I certainly wanted people to have it available, but times were so different then that the idea that I would be, in a couple and that we would have a kid, it was just probably still way beyond my comprehension at that point. But the truth of the matter is we already had in New York so many families who were just a reality on the ground that had, gay parents, mostly lesbians at that point, with kids. And it seemed to me that if New York was unable to even protect those families that already existed, even taking the risk without the benefits and protections of marriage, then it was going to be very unlikely to kind of spread or increase the protections in any other way. And of course, if you flash forward to Windsor, Justice Kennedy, in his decision, talked about the rights of children, and he talked about it at the argument in the Prop 8 case, and he wrote about it in Obergefell. So the same concept that we had, believe it or not, back in 1996, that whatever you think about these parents, it's so unfair to do this to the children, ultimately became something that I think was very, very powerful for Justice Kennedy, who was observant Catholic and who may not personally, approve of gay marriage. He certainly would disapprove, I think, of treating kids differently just because of who their parents were.
Yeah. Another sort of, there's no right or wrong answer to this question, but it's just an interesting thing to think about is in Judge Kaye's book, she talks about, and also in light of recent events, very sad events, Judge Kaye talks about when the US Supreme Court vacancy opened up in 1993, she was initially considered as one of the people President Clinton was thinking about and ultimately pulled out of consideration, and Justice Ginsburg got the slot.
Yeah.
But it's just amazing to think about what might have happened had Judge Kaye kept her hat, kept not pulled out of consideration and decided to maybe, who knows who would have gotten picked. But what are your thoughts about, can you give people a sense of why Judge Kaye, it's almost hard to imagine someone turning down an opportunity to potentially be on the US Supreme Court. Can you give people a sense of why Judge Kaye did that?
Yeah, so I think the reason is not too long before that she had become the Chief Judge.
Yeah.
And as people listening to this may not know, because it's ancient history at this point, she became the Chief Judge because the prior Chief Judge, Saul Walkler, had this pretty unsettling, let's put it that way, scandal where he was basically stalking a girlfriend. And it had come out that he had been stalking this girlfriend of his. And he had to resign, in under not great circumstances. And then Governor Cuomo, original Governor Cuomo, Governor Cuomo won, asked Judge Kaye to become the chief. And I think her view at the time was that having just taken over as chief, the first woman chief judge, in circumstances where her predecessor had to resign in disgrace, essentially, that it would not be fair either to Governor Cuomo or to the people of New York for her to then kind of have that job only for a little amount of time and move to Washington, D.C.
Yeah.
It was a very, I mean, it was a sign of Judge Kaye's integrity. I know she had a very good meeting with Bill Clinton at the White House, and I'm sure she did, because she could be incredibly charming. Both of them could, obviously. But in retrospect, I like to think that there's some force in the universe, whatever you want to call it, God or force, whatever it is. Ultimately, that force maybe had something to do with this, because I think both of them ended up in the perfect places for them.
Yeah.
Judge Kaye, not only being a leader on the law at the Court of Appeals, but really reforming the court system in some fundamental ways that people take for granted now, like jury reform, the commercial courts, which didn't exist before her, all kinds, family court reforms, et cetera. And Justice Ginsburg, of course, being such an incredible leader.
Yep.
On the Supreme Court, and then going on to spend, the latter part of her career on the Supreme Court as the great dissenter.
Yeah. And I was blown away in Judge Kaye's book. You just mentioned a couple of the things she's known for, and all of her accomplishments and legacy. She says in her book, "Matter of Jacob has been my greatest source of satisfaction." I mean, that's just blows me away, and it's so
I've
amazing.
got a tear in my eye.
It's incredible.
It was a great opinion.
Yeah.
And then it really was a huge, again, it seems funny today, but it was a huge step forward in the recognition of the equal dignity of gay people. There's no question about that.
Yeah. Just bringing this finally forward to sort of where things are as of today. There's a new case at the U.S. Supreme Court about, very different legal question, but it seems to me at its core, it's really about this sort of a similar question to Matter of Jacob. It's just about whether gay people come before the law on equal footing as parents, and whether there's something that should disqualify them from being parents. Where do you think things stand today, are in terms of?
So I really shouldn't comment on that. You can as my father used to say when I was a kid, you can interview me later.
Yeah.
Because my firm is counsel in that case.
Yep.
My partner Joshua Mass.
Who did our RBG panel, by the way.
Oh, good. So I shouldn't. I mean, he's got
Understood,
the highest IQ of anyone on the planet, but with the possible exception of Pam Carlin, and they're probably tied. But it's a very different world. I mean, there's no question. I'm perfectly comfortable saying this, that in the current environment, including the current Supreme Court, the greatest threat, I believe, to equal dignity for gay people and gay families is the so-called, because I don't think in these circumstances it really is free exercise, but the so-called free exercise of others who say that in order to comply with this otherwise neutral, valid law, like gay people have a right to get married, you are forcing me somehow to violate my religion. And therefore, and we just saw it recently in the, I think it was Justice Thomas dissenting from the case, denial of cert in the case about the Kentucky clerk, that I have a right to basically break the law when I believe the law violates my religion. And this comes up most commonly in the context of gay people. Now, what's really interesting about it, and I doubt the Supreme Court will grapple with this, but we briefed this in Windsor at the time, which is, and I briefed it in subsequent cases I did, that if you look at the history of Jim Crow, the same kind of religious arguments were being made by churches in the South about sitting at a lunch counter with a Black person or swimming in a pool with a Black person. Obviously, no one on the court thinks, I think today, that it would be okay to say that because my religion says X, I don't have to comply with the civil rights laws, at least as they apply to African Americans. But we still haven't come to the place in our country where that is true with respect to gay people. And what happens in the next several years is really going to be momentous. on those issues.
Yeah, absolutely. Thank you so much